This program is brought to you in partnership with the Immigrant Legal Center.
Welcome to Legal USA, a monthly program produced by New Americans Media in partnership with the Immigrant Legal Center, both of Omaha, Nebraska. We would like to stress that the information provided here is not intended to be legal advice. Viewers should consult a qualified immigration attorney to obtain legal advice on their issue or problem. Today, we will focus on UNT visa. Nancy Cardosa, a rural supervising attorney with the Immigrant Legal Center, is in the studio with us. Thank you for being here today, Nancy.
Thank you for having me.
All right, let's start with some definitions. What is the U visa and what is the T visa? What is the difference in between two visas?
Okay, so they're both non-immigrant visas, non-immigrant referring to temporary visas, temporary status. And so both of these visas are available to immigrants who have been victims of certain qualifying crimes and or victims of sexual or labor trafficking. In general, they both provide temporary relief, and so in the name it says, right, non-immigrant status, which is a status for 4 years if it is afforded to the victim. Along with that, you also get a work permit to be able to work lawfully in the country for those 4 years. It also has the ability to allow a person to apply for lawful permanent resident status after having the U visa for 3 years.
How are the crimes different for those two categories?
For the U visa, there's a lot more crimes that are considered qualifying crimes, and I actually have a list here. But some of the main ones that we see are domestic violence, sexual assault, or rape within our office, but there's a host of different criminal activity. The T visa is people are only eligible for that if they have been victims of sexual or labor trafficking. So it's more specific. And you asked about some of the main differences. And so for a U visa, for example, there is a cap of 10,000 U visas that are granted per year, as opposed to 5,000 T visas granted per year. So that's one of the main differences. For a T visa, there's no T visa certification that's required, meaning that a law enforcement agency does not have to sign a document saying that the victim was in fact cooperative, and a U visa does require that.
When and why were those two categories established?
So they were both actually established in October of 2000, and they were created by Congress, and they were actually enacted by the Victims of Trafficking and Violence Protection Act, which was meant to basically strengthen the communication between law enforcement and the immigrant community, right? It was also a segue for law enforcement to be able to investigate and prosecute certain crimes, as well as encourage immigrant victims to step forward and actually report these crimes. And so Congress actually noticed that immigrants were not coming forward. At least 70% of undocumented immigrants do not
Yes, I need to
report.
clarify that too.
Yeah.
They are within the group of undocumented individuals that
Correct.
are currently in the United States.
Correct.
Is that right?
Correct. And so 70% of these individuals do not report crimes, mainly due to very different barriers that they may face, right? One of them being fear of deportation or having any kind of legal repercussion, right? Okay. Others include maybe language barriers or cultural aspects, right? Maybe the crime is not a crime in their home country, and they come here and they don't necessarily know that it is a crime here. And so Congress did notice those barriers and therefore enacted these two statuses.
Now let's move to the procedures. What are the requirements that a person must meet in order to apply for U visa and T visa?
For the U visa, like I said, you have to first show that you were a victim of a qualifying crime. 2, you also have to show that you suffered substantial physical or mental harm. And how would you do this, right? So a lot of the times there is physical abuse, and so pictures or maybe even police records that show that there was physical harm done. But when it's more mental harm, that's where you can show different forms of evidence to prove mental harm, right?
Can you be more specific there?
Yes, for sure. So one example for mental harm would be maybe a letter from your counselor indicating any kind of diagnosis due to being a victim of a crime, right? A lot of our clients do suffer from anxiety or PTSD or some form of depression due to what they suffer. suffered, right? And so those are other forms of evidence that a person could submit to show that they have suffered substantial harm. You also have to show that you have been or are likely to be helpful in the investigation of the crime. And so a person normally shows this by having a law enforcement agency that either investigated, detected, or prosecuted the crime, by having them sign a document indicating that they were helpful in some way, shape, or form, right? And we call that form the I-918 Supplement B, also known as a U-Cert. So you'll hear me refer back to it as a U-Visa certification, and so that's what I'm referring to.
And when you say collaboration with the law enforcement or helpful, it's not just reporting the crime, is that right?
Correct.
What does that collaboration mean?
It looks different for each jurisdiction. So each state and law enforcement agency has their own policies on this, right? And so one thing I do want to clarify is that law enforcement agencies are not required to sign the U-Visa certification form. And usually from what we've seen, they make their own policies internally, right? So for example, if one of the law enforcement agencies is a police department, they may say that calling and just reporting the crime is enough, right? But maybe another law enforcement agency may think that that's not enough, and they may consider other forms of cooperation, maybe testifying or in court or going beyond that, right? Maybe more questions by an investigator, answering more follow-up questions. So it depends on each law enforcement agency.
Law enforcement agency, okay.
And so another requirement is that the crime must have happened within the United States, and obviously that the victim have some kind of knowledge and information about the crime.
The applicant is an undocumented immigrant here in the United States, physically present in the United States.
For a U-Visa, they don't necessarily have to be present in the U.S., so the crime has to have happened here. But let's say, for example, within that time frame, the person leaves or is forced to leave the country, they can actually still qualify for it being outside of the country.
Outside of the country, okay.
And that's for a U-Visa.
For a U-Visa, yes. Can we cover the T-Visa now requirements?
Sure.
Okay.
So for a T-Visa, like I said, there's a lot less qualifying crimes for that, right? So it basically has to do with sexual trafficking or labor trafficking. And you do have to show some form of force, coercion, or fraud that was involved in that. And for labor trafficking, for example, they look at labor or services that were provided in the form of like involuntary servitude, which means being forced to work against your will, peonage or debt bondage, maybe trying to pay off a debt that you incurred through your trafficker. And you also have to show that your physical presence or continued presence in the United States is due to this trafficking. And so a lot of people may have entered being trafficked by their trafficker, for example, or a person who is already in the United States may have suffered trafficking after entering the country, so not necessarily at the point of entry. So another requirement for the T-Visa is that they also have to comply with reasonable assistance to law enforcement in the investigation or prosecution of the crime. Again, there's no certification required by law enforcement stating that the person was helpful, but you do have to show enough evidence that the person did in fact cooperate in some way, shape, or form. Okay. So that's one of the main differences between the two, is that the U does require U-Visa certification and the T-Visa does not. And then the last thing for a T-Visa, the person does have to show that they would suffer extreme hardship if they were to be removed from the United States.
And how do you show that?
A lot of the times you can prove that either maybe the trafficker may be in your home country or just the conditions. They look at different things, so the person's age, their education levels, maybe their medical history, things that would make it harder on the person to be able to live in their home country as opposed to the United States.
While you were talking and describing the categories, we're talking about undocumented individuals that may not even have the courage to speak up.
Correct.
It looks to me like those are two very difficult categories to convince people to come forward.
Sure.
Is this feeling that I have correct, or this reasoning that I have, is it correct?
That is correct. And so that's why we try to do a lot of outreach on the topic, because number one, not a lot of individuals know about these forms of relief, right?
Okay.
And so people do fear, especially undocumented individuals, they fear deportation. That's probably their number one fear, right? If I call law enforcement,
Exactly.
they may come arrest me and not my abuser. And then another thing is the power and control that the abuser may have over the victim, right?
Yeah.
So threatening them with calling ICE, for example, if they call or report them to the police.
Yeah.
And so many different things come into play as far as to why a victim would not come forward.
Yes, and when you mentioned the counselor and a note from the counselor, I would imagine that someone who is not documented would not go to a counselor.
A lot of the times they don't, and so one thing that we have noticed obviously is that many of these individuals don't self-identify as victims. Some may know it automatically, right? So if you're a victim of like rape, you know you were a victim, or other qualifying crimes under the U visa, but under the T visa category, many people don't self-identify, right? So a lot of people don't know that if you're forced to work against your will, or not paid, or forced to do sexual acts, they don't necessarily know that that would be considered trafficking.
Okay.
And so when we meet with the clients, we usually do try to let them know, hey, there are other social service providers that you can go to get the help that you need. And it's easy to identify when a person may still have some kind of trauma left behind, and so we do try to refer those cases out as soon as we can.
Okay, Nancy, you brought here the list of the crimes. Can we please go? I understand that this is very detailed, but I would still like to go over them. So, is this group here the U visa crime?
The qualifying crimes that you see here are all for U visa categories.
All for U visa categories.
There's
about
at 26 or so.
26 are. Crime types, right?
Correct.
That qualify for.
Correct. And
U
so that's
visa.
very different from the T, right?
Yeah,
Where it's
was
just
the
two
two,
specific
right?
ones versus
And
general one.
Here I do see sexual exploitation, and there is sex trafficking and sexual abuse at T visa. How is this particular crime in U visa different from the T visa crime?
A lot of the times, both crimes can both qualify for a U visa and a T visa, right? So if you see here, you also have trafficking as one of the qualifying crimes, and so sexual trafficking would be under that, or labor trafficking as well. Usually the attorney reviews the case in detail and decides, which one would be better to apply under. One thing that we do take into account is the processing times, how long it's taking to get a U visa and a T visa. And so right now, for example, to be able to obtain a decision on a U visa, it could take anywhere from 10 to 12 years.
Okay.
As opposed to a T visa, which is taking anywhere from, I want to say, 16 to 33 months right now.
Oh, okay.
And so there's
substantially,
a correct.
Yeah.
But it's only when both crimes can either be under a U visa and a T visa category. That's when we kind of try to make a decision and know which one to apply for.
So let's say I came forward. I'm undocumented, but I decided to come forward, and you think that I do qualify for one of the visas, U or T visas. What are the steps that I need to take in order to start my application?
Okay, so normally we get referrals from either a law enforcement agency or just from clients who have heard of this specific benefit throughout the community or word of mouth, right? And so once we meet with the client, we analyze their case, we sit with them and go through all the facts, right? So from beginning to end, what exactly happened. And then after that, we determine, okay, which one of the two are we going to apply for? For the most part, we get mainly U visa applicants. We do get a lot of Ts, but I think for the most part, U visas are the ones that we do the most in our agency. And so after that, we may take a look at any police report that may have been done for the client. And so if they do have that in their possession, we'll review that with them as well. We'll ask questions as to whether or not they were helpful to the investigation of the crime. And if they were, we usually start off with the U visa certification first, right?
Okay.
So If the client says, no, I wasn't helpful, I was too scared, I didn't want to go through with anything, I decided not to press charges, then it can make it a little bit more complicated to get that U visa certification, because you have to show that you were helpful to the investigation of the crime, right? And so in that case, if we do determine that it is a U visa eligible case, we move forward with filing a U visa certification form request from the law enforcement agency. Okay. Just to make sure that they were cooperative, and again, that's one of the requirements. So we need that to move forward with the U visa.
Okay. And what else should be in that packet that you prepare? So
the U visa itself. So after we get the U visa certification response from law enforcement, we have 6 months to file that U visa. Okay. That certification expires within 6 months. So that's very important for us to get a handle on the application within 6 months. So we gather evidence, like I said earlier, as far as their identity, maybe a birth certificate, passport, and then also information about how they suffered substantial physical or mental harm in the case of a U visa. So we would file what's called the Form I-918, which is actually the U non-immigrant status application itself. And then we would also file an I-192, and that's a waiver of inadmissibility. And what I mean by that is under the INA, there's certain sections that make a person inadmissible to be granted any form of relief in the U.S. And so a person who, for example, entered the country without status would need to apply for a waiver to waive that inadmissibility ground. And so that's what the Form I-192 is for. And so the U visa itself is free. There's no cost to it. There is a cost and a fee for the I-192 waiver. And so
And how much is that cost?
It's about, I want to say $930.
$930.
Correct. And so there are fee waivers, and most of our clients qualify for a fee waiver due to their income. And so immigration also has income guidelines. So if that's hard for a person to pay, they can apply for a fee waiver, which is the Form I-912, very similar in numbers but different. And so if they qualify for that, DHS would waive the $930 fee.
$930 fee.
Correct. And so for the U visa and the T visa, the work permit application is usually automatically considered in the application. So, but we also try to apply for a work permit application separately, because it usually would fall under a different category. So one thing that I didn't mention to you earlier is that I did say that there is a wait time, right, for about 10 to 12 years for a U visa. And so what happens in the meantime, right?
Exactly.
Is a person in limbo. And so usually...
Can that person work?
And so not automatically. So they do have to wait about, right now it's taking about 4 to 6 years for immigration to even look at their paperwork, right? And so once USCIS reviews their documentation and determines, okay, well, you know what, they do qualify, but we've given out all the U visas for this year, right? They've met the cap, so they put people on a wait list. Okay, and for a person to get on that, like I said, it takes about 4 to 6 years.
4 to 6 years.
Correct. And once they are put on a wait list, they're granted what's called deferred action, which is basically Department of Homeland Security saying you're not a priority to be deported at this point in time, and so we're going to go ahead and grant you the ability to apply for a work permit.
So that individual can stay in the United States for the time being, but cannot work.
If they are granted deferred action, at that point they can apply for a work permit.
All right.
Correct.
Okay. So
and then once that work permit, I want to say it's granted for about 2 years at a time, if I'm not mistaken, and you can keep renewing it until your U visa is finally approved.
Okay.
But again, you have to be put on the wait list first.
If I'm prepared, I qualify for them, where do I send my application? Is that a specific center that deals with that?
Yeah, so under USCIS, the Vermont Service Center is usually the one that processes both the U and the T visas. And then right now, the U visa, since there's so many pending, there's about over 141,000 U visas that are pending right now with the USCIS.
141,000.
Correct. That's why the backlog is so long, 12 to 14 right now.
12, 14 years.
Correct.
Over 10 years.
Correct. And so in the past, this was not the case, right? In the past, since very little people knew about it, I believe the cap was actually reached in 2010 for the first time, if I'm not mistaken.
Okay.
And so since then, it's just been a backlog.
I'd like to move now to the benefits of this category. Do any family members qualify for these benefits?
Yes, they do. And so that's actually something that I did want to talk a little bit more in detail. There's 3 different types of victims, right? You have the direct victim, which is the person who actually suffered the harm. If the direct victim is over the age of 21 years old, they can actually also submit an application for a U category for any spouses or children under the age of 21 that they may have. Now, if the victim is under the age of 21, there's only certain family members that could qualify as well. That would include their spouses if they're married, any parent, or any sibling under the age of 18, or any children that they may have. And then you also have the indirect victim, which this is basically where the direct victim is either deceased due to murder or manslaughter, for example, or is incompetent or incapacitated. Maybe they're a minor or under the age of 16 for this purpose. And so they may not be as cooperative with law enforcement, but the parent probably was, right? And if the parent is undocumented, they could come forward and apply as an indirect victim. For example, the spouse of a undocumented individual or a documented individual who may have been murdered. And in that situation, the spouse, if they cooperated with law enforcement and meets all the other requirements for a U visa, they could qualify as an indirect victim themselves.
Okay,
Correct.
and the third victim?
The third type is a bystander,
Type,
and that's
yes.
usually a witness that also has to show that they suffered substantial harm. And an example of this, the one that many people give, is like a miscarriage, right? So let's say a pregnant woman may have witnessed a person being murdered or being robbed at gunpoint, and due to this, she may have suffered a miscarriage. And so that's a good example of a bystander who could also qualify for a U visa if they also meet all the other requirements as well.
Does the time of the crime, when the crime happened, impact the ability or the eligibility of a person to apply for a U visa or T visa?
It shouldn't, because there is no statute of limitations
Okay.
under the U visa category, right?
Okay.
And so that means that a crime could have happened 15 years ago, and as long as the law enforcement agency is willing to certify that the person was in fact cooperative, in that case, it could still move forward.
Can a person who has applied for a U or T visa and the case is still pending, can that person be put on removal proceedings?
Yes, they can.
They can?
They can. It all depends on a case-by-case basis and how things happen, right?
Okay.
So usually immigration judges in the past were very understanding, and there were a lot of policy memos that indicated the steps that either a judge or ICE counsel should take when dealing with the victim of a crime who has a pending U visa, right? However, a lot of that has changed with the new executive orders and policy changes that have been implemented.
Mm-hmm.
And so instead of granting a continuance, which is in court, an extended date that would allow more time in order for the U visa to be decided, usually that's not really being granted anymore. And so what happens is sometimes the person is either asked to choose between a voluntary departure, for example, versus deportation or removal.
Okay.
And so in the case that a person is ordered, deported, or removed, at that point a person can apply for what's called a stay of removal, which basically is what it sounds like, right? Like a halt or a stay, a stop to the removal process.
If let's say in the worst case scenario there is no, the judge decides that no, we'll proceed with the removal.
Mm-hmm.
That's the end if you're applying for a T visa, right? The U visa you can still pursue if you are outside of the United States, but for the T visa, that's the end of your journey.
Correct.
Is that right?
But again, like I said, you can still ask for a stay of removal.
Can the perpetrator also qualify as a derivative?
No.
No.
No, they cannot.
Okay.
So the perpetrator or the abuser cannot benefit from any form of U visa or T visa relief in that specific case.
What if the victim has a history, a criminal history? Can that person still apply for a URT visa?
Yes, they still can. So one thing to keep in mind is that USCIS does run a FBI fingerprint check on each victim after applying for the U visa. And so depending on their criminal history, they do outweigh their history versus the good and the bad in regards to whether or not to allow them to stay in the country, right? So when we submit evidence with the U visa, if we know that our client has criminal history, we do try to show some form of rehabilitation.
If I was deported previously, can I still apply for a U visa or T visa?
Yes,
you can.
You can. And so again, that goes back to the inadmissibility waiver that we spoke about earlier.
Right.
And so being removed previously from the country is a form of inadmissibility ground, right? And so there is a way for you to waive that, depending, again, it's on a case-by-case basis, how things actually happened, if you're back in the country or if you're still outside of the country.
I think U visa, T visa open you a path to citizenship, as you mentioned. Correct. You don't need to wait. You can just apply after 3 years.
Correct.
Right?
One requirement is that the person has to still show that they were cooperative throughout the entire time. So let's say a person applied for the U visa and was granted a U visa, they still have to prove that throughout the time that they had the U visa and the time that they applied for the green card, if the case was still open, that they continue to cooperate with law enforcement.
That means that the law enforcement is still investigating the
Correct.
case, hasn't reached a decision
Correct.
on the case?
Correct.
Okay.
But a lot of the times our cases are closed, right?
Yes.
So, so you still have to prove that during the time that the case was open, the victim not once failed to cooperate. And so if that's the case, you can move forward with lawful permanent status for a U visa. After having lawful permanent status for 5 years, then at that point they can apply for citizenship.
Okay. Correct. And is it the same for T visa as well?
Correct.
All right, 3 years for T visa as well, right? And then plus 5 and then citizenship.
Correct.
The pending cases, I remember for U visa was 141,000.
Yes,
How about the T visa?
T visas, I believe right now is about 2,000 U visas pending.
2,000.
And then if you calculate also the family members, it's a little bit higher, but the T visas have never actually reached their cap. And so the U visas, like I said, they've reached their cap for quite some time now.
Thank you, Nancy, for being here today.
Thank you for having me.
All right. This was Legal USA for this month. Next month, we will cover Violence Against Women Act, or VAWA. If you have questions, please email them to us at legal@newamericansmedia.com by August 21st. And we will see you again here on KPAO TV or online at www.newamericansmedia.com on September 2nd. Thank you for watching. I am Enkela Bebio.